Okay, once again, good morning, everyone, and welcome to this very interesting webinar with the theme Introduction to Intellectual Property Rights in Relation to Trademark and Patent Protection. And this webinar is brought to you by the Directorate of Innovation and Digital Technology under the headship of Professor Ayanda. My name is Naziru Imam, and I will be the anchor for today's webinar. We have few series of line of activities for the webinar, and we are going to commence right away. The first item we have here is the welcome address and introduction of participants by the Director of Innovation and Digital Technology, Professor Ayanda. Prof, if you are here with us, please kindly go ahead and give your welcome address.
Ah, Thank you very much, Mr. Naziru Imam, for anchoring this program. And before I go ahead with my speech, I would like to remind you to please make the guest speaker a co-host so that he will be able to share his slide. His name is, I think, is
Okay, let me
Godwin.
let me do that. Let me
Do
try
that,
and
yeah.
do that.
So I recognize the presence of the Vice Chancellor in absentia and the Deputy Vice Chancellor, SPRI, of our great institution. And I also acknowledge the deans and directors, heads of departments, esteemed staff, and our dynamic students that are here today. It is with great pleasure that I welcome you all to this important webinar on intellectual property rights in relation to trademark and patent protection. I extend our deepest appreciation to our speaker of today, in the person of Mr. Uche Obiajuwa, for yielding to our call and then for delivering this insightful presentation. The purpose of the webinar now, our students have demonstrated remarkable creativity and innovation, developing numerous groundbreaking products. At FUOYE Innovation Lab, we have people that have developed so many products, and then we find it deemed fit that we need to take them through the intellectual property rights so that at least they know what is obtainable. Many of them, they quickly rush to the government or possibly rush to the individual without proper protection of their product. And I always tell them that if you don't do the right thing, the government, they have the money, they have the resources in order to go far ahead of you, and then they can steal such products. So it is crucial that we take proactive steps to protect all our innovation at a FUOYE Innovation Lab. So we encourage our staff members to also consider patents for their intellectual contributions rather than publishing their work. We discovered that many of us, our staff, all we know is about publication and publication. And there, I think it's right time that we encourage our staff as well to start working on patents, at least to get their products into the market. So to address all this, we actually organized this webinar to equip everyone, including staff and students of our great university, even their alumni, with a clear understanding of intellectual property rights and the legal avenues available for safeguarding innovation. So we are privileged to have here with us Mr. Uche Obiajuwa to lead this session. I met Mr. Uche Obiajuwa at Innovate Lab. When I got to the Innovate Lab, I've always thought I'm very good and I'm always being the best. But when I got there, I discovered that I know nothing because of those people that I met there. They are all people that are highly intelligent. And then I made it, I took it upon myself that I will try my best or everyone that have taken me through innovation courses from there to our university so that our staff and students can also gain and learn a lot from them. And after this session, I will also ask Mr. Obiajuwa if I can add him to our platform. We want him to be able to guide and to guide our students with innovation as well. So he is a recognized intellectual property, and I can personally attest to his depth of knowledge, having of Abuja. So with his wealth of experience, I am confident that both students and staff will derive immense value from this webinar. I would also like to express my profound gratitude to the Vice Chancellor of our great institution for granting me the opportunity to serve and for his support of all our programs. His commitment to fostering innovation and intellectual growth within our institutions is highly commendable. Once again, I thank you all for your presence and engaged professional pursuits. Thank you very much. Mr. Imam, you can take over, please.
Thank you so much, Prof. And before I proceed, I would like to make it known to all participants that please, this session is not being recorded. So kindly try as much as you can to take notes of anything important that may be useful to you after the presentation. Just get a note beside you, maybe a jotter, and be taking note of the presentation that is going to be made by the guest. Additionally, this session is going to end in the next 1 hour, as it is a free Google Meet that we are using. So please take note of that also, the presenter. Thank you so much. And the next item on the agenda is the Vice Chancellor's remarks. And I would like to call on the Vice Chancellor to present his remarks. Is like no. Okay. In the absence of the Vice Chancellor's remark, in the absence of the Vice Chancellor, maybe we'll get back to that. I would like to move on to the next item on the list, which is the citation of the presenter before his presentation. And permit me to briefly go through that. Okay. Distinguished participants of the webinar, the Vice Chancellor, the Director, and other participants, permit me to present to you our guest, Uche Obiajuwa. He's a highly accomplished intellectual property expert that boasts an impressive academic background, graduating with honors in English and Literary Studies from the University of Port Harcourt. He's committed to staying at the forefront of IP protection, and he pursued advanced studies with the World Intellectual Property Organization Academy in 2021. This specialized training, coupled with various degree and certificate programs in IP, has equipped Uche with expertise in navigating complex IP landscapes. A seasoned practitioner, Uche has successfully drafted and registered over 50 IP protections within the last 3 years, which demonstrated a keen understanding of the intricacies of IP law. Currently, Uche serves as lead consultant on intellectual property at Godwin's Integrated Ventures Limited. In this role, Uche provides expert guidance to local and international businesses, facilitating the protection and domiciliation of innovations across the globe. So permit me to present to you our guest, Mr. Uche Obiajuwa, for his presentation. You are welcome, sir. You can go ahead and share your screen, sir, for your presentation.
Okay, good day, ladies and gentlemen. Can you hear me?
Yes, we can hear you.
Okay, the Vice Chancellor, Federal University, Oye-Ekiti, Professor Abayomi S. Fasina, the Deputy Vice Chancellor, Strategic Partnership, Research, Innovation and Linkages, Professor Joshua Ogunwole. I won't forget to recognize my very good friend, Professor Ayanda, who has practically reminded me of this webinar since last year. So I want to Thank you for the honors of having me this morning. And I'm going to make it short and brief because of the time and the schedules of distinguished guests here. Let me share my screen again. I don't know if you can see my screen.
Not yet.
Okay. Have you seen my screen now?
Yes.
Yes.
Okay, fine.
I think we can.
Okay, today we'll be talking about introduction to intellectual property in relation to trademark and patents. You will ask yourself what is actually intellectual property. But before I delve into that, you cannot talk about innovation in 21st century without talking about its protection. Um, Having said that, let me go to my slide. Okay. Okay. Like the anchor said, my name is Uche Obiajuwa, IP specialist and expert in Godwin's Integrated Ventures. Um, so at the end of this class, you understand the concept intellectual property. You get acquainted with industrial property rights in Nigeria. You will talk about trademarks rights and patent rights, and we will now ask questions and conclude. So, what is intellectual property? I don't know if anyone has an idea of what intellectual property means. So, I want my class to be an interactive class. So, you might want to mute your mic to answer my question.
So I think my name is Adibayo Joshua,
Okay.
and all that I know about intellectual property is something that something that is being done, an innovation or product that comes from someone idea or his knowledge. Like he sat down to do something, it is his own idea. So that's what I believe to be something that is intellectual property. So it belongs to him because he's the one that did it.
Okay. Any other one? No answer is wrong. Just feel free to. I want it to be interactive, so I will learn from your own knowledge and you learn from mine as well, because I know I'm speaking with distinguished lecturers here. So let me hear your own knowledge.
All right, sir. Good morning, sir. So my name
Okay.
is Peter Takwe Blessing. So in my own understanding, I think intellectual property is there are properties that are governed by law that are registered. So the government is aware that you own this certain property. So that is my own contribution to the question, sir.
Okay. Okay. Any other person? Just one more. One person. One last person. Okay. Let's continue because of time. So intellectual property is simply the creation of the human mind. That's simply what it means, the creation of the human mind. So when you come up with an invention, when you come up with literary work, or when you come up with artistic work, or design, symbol, anything you can create with your human mind, that is your intellectual property. That's your property, which is coming from your intellect. That is simply what it means. It can be names, it can be inventions, it can be literary or artistic works, it can be designs, it can be symbols, it can be images, it can be trade secrets, it can be confidential information. So these are some of the intellectual property we use on our day-to-day activities. Cars, pens, chairs. People actually thought of this to produce it. That is why it's called an intellectual property. You write a book, you are a lecturer, so you write a book, and at the end of the day, that is your intellectual property. That is your intellectual property. So in Nigeria, intellectual property is divided into two branches in Nigeria. One is the copyright, and the other branch is the industrial property rights. So today we'll not be talking about copyright, but I will just give some little information about it. Copyright has to do with your publications, your books, your music production, your films. You are aware of the recent situation with Messi Chinwo. For those of you that are Christians, Messi Chinwo and what's it called now? Their music film and all the rest of that. So it has to do with copyrights. So and under that's copyright now. Now, copyright, no matter what you do under the copyright, especially publications of books, it's the duration of it lasts for the lifetime. Copyright lasts the lifetime of the publisher and 70 years after the demise of the publisher. That's for copyright. Well, I'll be talking about trade. I'll be focusing more about trademarks and patent. Maybe in our next webinar, we can now talk about industrial designs and copyright properly. So what is trademark? So before I get to what trademark means, we'll talk about how intellectual property works in Nigeria. Now, for patents and trademark, the only place you go to file your patents and trademark is under the Federal Ministry of Industry, Trade and Investment. Any other platform is dubious. So once you want to file your intellectual property, patents, designs, and trademark, you go to the Commercial Law Department. Then for patents and designs, you go to the Patent and Designs Registry. For trademark, you go to the Trademark Registry. So let us talk about trademark. So do you have an idea of what trademark means? Anyone? Anyone?
Yeah, great.
Okay, let me continue. So trademark. So
Trademark is
okay, someone's talking.
symbol, like just like a brand identity that
Exactly, brand identity. Exactly, brand identity. So you have a brand and you want to enter the market space. What will people remember you? If someone wants to, maybe someone has used your product before, or someone can attest that your product is good, what will they use to remember you for in the market space? That's what trademark does. So trademark is a graphical representation which distinguishes the goods and services of one business from another business, and also identifies the sources of those goods and services. So that's what trademark does. Trademark distinguishes you. Trademark gives you an identity in the market space. So these are some of the familiar trademarks. ESUT, Covenant University, Waterloo, all of them. This is what they use for them to be recognized in the market space. Coca-Cola, you can't see Coca-Cola logo and call it Fanta. You can't see Coca-Cola and call it Sprite. They all have what distinguishes each from another. Like we have different types of table water now. We have Eva, we have Nirvana. So you cannot see Eva and call it Nirvana table water. Something distinguishes the two, which is that trademark. Trademark is very, very important in the market space for you to be recognized and for you to be distinguished from one brand, from one brand to another. So these are forms for new people that want to go into the market space. These are some ways you can do your trademark. You can use the Coca-Cola style. You can use any style you want. It can be in writing, it can be in logos, it can be in color, mixture of colors. So anyhow you want to present yourself that will distinguish you from the market space. That is what we are talking about. That's what we are talking about. That's what we are talking about here. So you need to be distinguished for someone else not to be benefiting from the services or products you render. So classes of trademarks. We have product marks, we have service marks. So under the product marks, you have Indomie, Milo, Fanta. These are products. They take in products into the market space. But service marks such as Covenant University, Sheraton, Godwin's Integrated Venture, all these they render services to the public. So you need to differentiate these two. You need to differentiate these two and know what you are actually doing in the market space. Are you producing something, or are you rendering a service? Can you people see my slide?
Yes, sir.
Okay, because I think someone is in the comment
Yeah,
section. Maybe.
I can't see any slide there. Only a logo of Godwin Integrated or something like that.
Well, for me, I can see the trademark slide, but it has been on the trademark since.
I can see the slide.
Yeah, I
Okay.
can't see anything there.
I can see the slide.
Can you continue
Product
with your next section?
Indomie, Milo, Fanta, Covenant
Okay.
University, Sheraton, that one.
Yes, that's where we are. And I don't know why some persons cannot see the slide.
Probably the network issues. It could be their network.
Okay. Please, you might want to change your position.
Those looking at Godwin International, they should also look at another window. It appears maybe the presenter is using two devices or so. I don't know. But don't look at the Godwin. The Godwin will not give you the slide. Look for another window where the slide is.
Okay, let me continue. So basic facts about trademark. You should take note of this. I learned we are not recording, so you should take note of these basic facts about trademark. Trademark are territorial rights. What this means is what protects you in Nigeria as a territory does not protect you outside Nigeria. So you will need to go to any country of your choice, any other country you want to do your business, to go and register your trademark. Trademark are federal rights. That means that it's only the federal government that can grant you trademark. Trademark can last forever and can also elapse. I will explain this point further in our subsequent slide. Trademark are transferable rights. You can transfer it, you can will it out, you can sell it, whatever you want to do with it. A trademark is different from a business name or a company name. Remember, when you want to register your business name or your company name, you go to CAC. That's Corporate Affairs Commission. You go to CAC. But this one has to do with your identity. You register it with the trademark registry. A trademark has for 5 different classes. It's different. It's categorized into 45 different classes. From 35 to 45 covers services, while the others covers. Please, can you mute your? While the others covers products. You do not need to register your trademark to use them. What this means is that nobody will arrest you one morning for waking one morning to take up a logo to register your business. But when you will be arrested is or when you face the law is when you use someone's logo that has registered to represent your goods, or when someone registered before you came up with a logo and someone you are using the logo and someone went behind your back to register it before you. The law recognizes who came to register first. So that is, but nobody will disturb you for waking up one morning to use one logo or the other to represent your business. So lifespan of trademark. Trademark has an unlimited lifespan, but you do your registration, you do your renewal. First renewal is 7 years, then subsequently you renew every 14 years. Not renewing means that it falls into the public domain whereby anyone can use it. It falls into the public domain whereby anyone can use it. So you need to register your trademark. You need to register your trademark and also renew it every 14 years. So I told you trademark can last forever and can also elapse. Now, how can trademark elapse? Trademark can elapse if you do not register it. If you do not register it, someone can register it before you, and at the end of the day, the owner is the person that registered it. If you do not renew it every 14 years, you do not have guarantee of it lasting forever. It's your right to protect your trademark against infringement. It's your right to protect your trademark against infringement. So someone can enter from one village and be using your trademark to sell his product. It is you that will go and find out and report to the authorities, the right authorities, for prosecution. So it is you now that will protect your trademark against becoming generic. How can a trademark become generic? We'll find out now. A generic mark is a brand name that because of its popularity or significance has become a general term for goods and services. Sorry, let me adjust this. Can you hear me?
Yes, you can.
Yes, sir. We can hear you.
A generic mark is a brand name that, because of its popularity or significance, has become a general theme term for class of product or services. So there is how popular your product can be in the market space, and it becomes a problem. Let's see some of products like that. Pampers. You know the original name for Pampers is diapers, right?
Yes, sir.
Yes. Indomie. The original name for Indomie is noodles. Now, when you go to a market, a shop, and you say Indomie, they can bring in any type of Indomie. Uh, Sellotape. Sellotape, the original name is plastic adhesive tape. Now, how many of you know that kerosene? Kerosene was a trademark.
I didn't know that
Hello,
before.
have you heard that
I
before?
didn't know that. I didn't know
Just
before.
learning that.
Just
So
learning that this
I'll
morning.
just give you some minutes to browse it out. Maybe check on Google. I made this argument with a former director in NNPC. She was arguing that why can you tell me that kerosene is a brand, it's a brand name of a product, when we've all learned in chemistry and in physics that kerosene is it's a chemical. Or the, ah, until I told her to open her Google space. So check it out. Check it out. Let's know what you can see.
I just check it out now.
Okay, what did you see?
I saw that Abraham, is it Jesner, a geologist and inventor from Nova Scotia, registered the trademark for kerosene in 1854,
Exactly.
but the trademark
Exactly.
eventually became generic.
Exactly. That's the point. So look at what you saw there, right? Now in 1854, someone woke up one morning, produced a paraffin oil, and used kerosene as the trademark. And because of how the name is very long, people started calling it kerosene. People started calling it kerosene. So it can be a problem when your innovation becomes so popular in the marketplace. It can also be a problem. But there are some ways some companies have decided to solve this problem. Some companies have discovered this problem and they decided to solve it. Let's look at one or two companies and know what they did. So this is Shell. Sorry. Okay, this is Shell. Shell decided to be changing their trademark. After some years, they will change it. After some years, they will change it just to maintain that relevance, just to avoid their trademark from becoming generic. So in 1909, they used something different from what they used in 1930. In 1930, they used another. In 1948, they used another different thing. In 1955, they used something different. In 1961, they used something different. They kept changing it just to just to maintain the fact that their trademark does not go generic. So we'll check another company and you will decide on which one to use. So this is the milk industry, Finland Campino Wamco Nigerian Limited. So what they did was to produce different types of milk and produce different trademarks for them. Are you aware that the owner of Peak is also the owner of Three Crowns? Who is aware here? Hello?
Hear you, sir. We can hear you.
So are you aware that the same person that owns 3 Crowns is the same person that owns Olympic and Peak Milk?
No, sir.
Yes, I think I'm aware.
Pseudo competition.
Sorry?
Pseudo competition. They are creating a
Yes.
brand. Pseudo competition, creating multiple brands to saturate the market so that other people feel this.
Sorry, you call this studio competition?
Pseudo, PSEUDO. Pseudo competition.
Okay. PS. Okay. So this is actually a way that this company decided to protect their brands. So thereby creating competitions for themselves. So if you decide to go and buy Peak Milk, you are still patronizing and say you will not buy 3 Crowns. You are still patronizing the same person. So anyone that you can use to make sure that your innovation, your trademark does not go generic, please use it. So importance of trademark, effective communication tools, the importance cannot be overemphasized. Easy for customers to find you, early businesses to effectively utilize the internet and social media space. It's a valuable asset. It can be mortgaged, it can be wheeled out. So the importance cannot be overemphasized. Now, I want you to unmute your mic. Look at these 2 bags. Let's do a little exercise. Look at these 2 bags. One is $30 and one is $3,000. Why?
Because of the logo.
Because of the trademark on it, the logo, the Louis Vuitton logo.
The Louis Vuitton logo. What if I tell you that the original of this bag is the one without the logo? It's possible, right?
Yes, sir.
So you can now see the importance of having a logo attached to your innovation. Can you mute your mic? Okay. You can now see the importance. This one, because it does not have logo, so everyone thought it's fake and they are pricing it for $30. Now the one with Louis Vuitton logo handbag is now priced for $3,000. That's the importance of having a trademark. That's the importance of having a trademark. So please, before you go into the market space, for those of you that are students that might want to go into commercialization of one intellectual property or the other, you try as much as possible to have a logo and a registered one at that. Okay, let's look at criteria for registration. You must have a registrable trademark. That is number 1 criteria. It must be registrable. Then, how do you know that a trademark is registrable? One is that the fact that it must fall into the 45. Remember, I told you there are 45 classes. It must fall into the 45 classes. I will share the, because of time, I will not go into naming, but I'll share the slide, the document with Professor Ayanda that lists the 45 different classes. One has to do with chemicals, one has to do with, just name it. It's up to 45, but it must fall in one category. What are you doing? Yes. So it must be distinctive and not common to the trade which it represents. It must be distinctive and not common to the trade which it represents. Like Apple. Apple is a good trademark for computers, but not a good trademark for juice. So you cannot use apple now for juice, like to say apple juice, using apple as your trademark, because apple apple is a kind of a name for a fruit that can be used to do juice. So you cannot use apple now again as your trademark. Spoon is a good trademark for clothing, but not a good trademark for kitchen utensils. It must not be confusingly similar or deceptive to the trade to an already existing mark or well-known mark. Look at the two Pepsi. From looking at it, you can differentiate which one is the original one, which one is fake. Look at Milo, look at Seaway there. So looking at them, you can differentiate. So you cannot use, if you use something similar to it, it cannot be registered. And if you eventually use it, you might be sued or prosecuted for that. So must not show superiority in the market space, like to say Super Sunny, Great Cola, fortified dollar. You cannot come to the market space and you start showing superiority. Trademark registry will not accept such trademark. It must not be a place, a name of a place or a country, like to say Havana Loaf, Delhi Soap, Ghana Flex. You cannot use such names to such. Definitely, they exist. Such things exist in the market space, but bear it in mind that they are not registered. They are not registered. It must not be contrary to public policy or morality, like to say Igbo takeover. Something that will bring contradiction in to public policy and morality cannot be registered. So let's delve into patents. So any questions so far on trademark? Or okay, maybe we should wait till after the lectures. We can now ask our questions. But if you have any contribution to make, you can also share with us. Any contribution so far? Okay, let's continue to patents. So, what is patent? Patent is an exclusive right given to an inventor by the government over his new product. It is an exclusive right given to an inventor by who? The government over his new product. It is only the government that can grant an individual this exclusive right. Only the government of a country. So unlike trademark, patent is also territorial. So it can also be an improvement of an already existing invention. Look at the two televisions. The person that did the color TV, you will agree with me that the person deserves the patent protection for the innovation, the improvement. You look at the two telephones, there is an improvement. Now let us look at the recent one now, Tesla. So Tesla wanted to go into cars. So he asked the Elon Musk and his crew, sat down and they asked, what can we do to make our car unique? Now, what they did was to go into sustainable energy. Now, what can we do under sustainable energy? What can we use to make our car so unique and not look like every other cars, every other traditional cars out there. So they decided to bring in sustainable energy to their cars, which is very unique. So someone that came up with such an idea needs protection for that innovation. Needs protection for that innovation. So patent gives the patent holder the right to exclude every other person from making, selling, exporting, or importing the product. So that is the right you get as a patent holder. You exclude every other person from making, selling, and exporting or importing the product without your permission, without you granting them license to do that. So that is the right of a patent holder. So when you want to file a patent, these are some of the critical criteria you must meet. You must have a proof of payment for your patent, application letter to the registrar it's in a form format.
Hello,
So,
sir.
okay.
Yeah, sorry for the interruption, sir. This meeting is going to end in the next 3 to 4 minutes. So after it ends, we may have to rejoin the meeting again. Sorry, because we are using the free version of the Google Meet.
Oh, okay, no problem.
Yeah, thank you.
No problem. So,
Dr. Abalode here.
So power of attorney, patent specifications, which comprises detailed description of the invention, abstract scope of the invention, technical drawings, and the claims which you want the registry to grant you for. So this is a typical example of what a patent or the certificate you receive. It has your patent number, inventor's details, title of invention, chief registrar's name, date of invention, filing date, date of issuing, sealing date, priority date. So unlike trademark, which we say lasts forever, patent lasts for just 20 years. So after 20 years, you either it's not actually renewal now, you improve on it. You improve on it. You improve on the patent and file again. You improve on it and file again after 20 years. But you also need to keep renewing it, like to tell the government that you are still making use of this patent every year. You need to tell the government that you are still making use of this patent every year. The patent lifespan is 20 years, patent annuity every year. So important facts about patent rights. Patents can be assigned, mortgaged, licensed.
About to end.